All right, welcome everyone to today's August 2nd coffee hour from the Senior Health Division.
Excuse me, August.
The August, April. They all start with A. I wish it was August. Don't believe me. I want this year. I would like this year to end. But yeah, sorry. Welcome to our April SCD coffee hour from the Senior Council Division. Today we have William Meyer from Sadler Meyer Law. But he also goes by Bill. So Bill began practicing business law in Hawaii in 1979. His practice emphasizes intellectual property law, including copyright, trademark, and right of publicity, license, and registration, entertainment, trade secret, art and advertising matters, government relations, real estate matters, and related dispute resolution, including litigation, arbitration, and mediation. With that being said, take the floor.
Thank you, Desmond. Everybody in present and out there in Cyberland. I get to talk about two of my favorite subjects today, copyright law and the fact that our robot overlords are out after us. I'll be spending most of the time on the former, and if there's any time left, I'll refer to some of my thoughts on the latter. We're going to be talking about generative AI and Registrar of Copyright Perlman's three-part report. So I want to kind of set the stage because you've probably all heard terms like generative AI and AGI and ASI, and just to put things in context for you. There's a kind of a through line you can draw from all the way back to Alan Turing's attempts to crack the Enigma code. Actually, you could probably go further back than that. You could probably go to Descartes and I think, therefore I am, and our fascination with human cognition, what the nature of consciousness is, etc. So it's that sort of interest which drove Alan Turing to use machine learning really for the first time to solve a very complex problem, which was the Enigma code, which was the cryptology that was used by the Nazis during World War II to secrete the locations of their U-boats. Those U-boats were wreaking havoc because the United States Merchant Marine Fleet was bringing all kinds of supplies and stuff to the UK. And the Germans had a very solid cryptology where they could hide the location of their submarines, and cracking that code was instrumental in stopping the destruction of the supply chain to the UK, and ultimately led to the Normandy invasion and our ultimate success in World War II. Alan Turing was a mathematician in England, and like I said, he was fascinated with the idea of machine learning. And as time went on, various labs have been set up across the world, notably in the UK. And the one that remained prominent in this particular field is DeepMind. DeepMind was started by Demis Habbabis. I always torture his name. And he was an incredibly brilliant young man. At age 4, he was already a chess master and went on to become the king of most board games, including the ancient Chinese game Go. And initially, the lab was set up strictly for scientific purposes to, again, try and understand human cognition and how the brain operates. The ultimate goal of the DeepMind and the other large language models that we have is to attain what's known as artificial general intelligence. Now, what does that mean? Artificial general intelligence is bringing machines to the point where they can execute most of the cognitive functions of the average human being. And the cognitive scientists refer to that as minimal AGI. And we haven't achieved that yet. We certainly haven't achieved sentience with machine learning. So once you can get a machine to the point where it can deal with a multitude of different type of tasks, essentially problem solving, then we will have probably crossed the line into AGI. But I should emphasize that it's not a bright line distinction. It's more of a spectrum of progress. For a long time, we've had machine learning that has been very proficient at a specific type of tasks. You may remember many years ago when IBM's Deep Blue beat Barry Kasparov in chess. And that blew everybody's mind because for the first time, a machine was able to beat a chess master. But that was a very focused and narrow type of activity. Downstream, you may have also recalled, I think this was in the late 70s or the early 80s, Deep Blue took on the world champion Jeopardy player and actually beat the world champion Jeopardy player. Again, these were machines that were incredibly proficient, probably better at very discrete, isolated tasks than most human beings. So you have this notion of minimal artificial general intelligence. And that will be when a machine can do basically everything that the average human being can accomplish. And when we progress from that, we move into what cognitive scientists are referring to as full AGI. And that's when machine learning will be able to execute virtually every cognitive function that human beings can execute at the very highest level. So we're talking there about Einstein-type intelligence. Is there a step beyond that? Yes, there is, and that's artificial superintelligence. ASI, they anticipate, will be an intelligence that surpasses the limits of human cognition. And that is where the issues of alignment and containment become very important. I am always surprised at least my law colleagues in how insouciant they are with respect to the gains that are being made and where ASI will ultimately take us. There are lots of cognitive scientists they're just not so equanimous about this. They recognize the dangers. So you have people like Kristen Harris, who was the ethics officer for Apple, coming out and basically warning the public about where this is going and that it poses existential threats to our species. Geoffrey Hinton, who won the Nobel Prize in his discoveries in artificial intelligence, is devoting all of his time now to sounding the alarm. In the cognitive science arena, these folks are referred to as the scouts who are out there trying to warn people what's going on. I'm not going to be talking much about that. It's a fascinating area. If you're interested, I would recommend that you look into two publications. One was originally published on Substack, and it's called The Intelligence Curse. It borrows the macroeconomic theory of the resource curse and basically takes you through how AGI is going to start rooting out all low-level jobs. And when I say low-level jobs, these are jobs, if you can do your work remotely by sitting behind a screen, you're a cognitive worker. And those are the jobs that are going to be hollowed out over time. The intelligence curse will take you through a very detailed explanation, not so much a forecast, but they'll give you an idea of how this thing is going to progress and the problems it's going to create. The other paper that I suggest you look into is it's a forecast. There are folks now, because this area of technology is moving so quickly, there are folks that are actually devoting full time to doing what's known as forecasting. What do I mean by forecasting? 5-10 years ago, these folks were trying to anticipate how quickly we would see AGI and ASI. And the timelines used to be 30, 40 years, et cetera. And they keep getting compressed because the technology just keeps evolving so quickly. And so they're now actually looking at timelines of 1, 2, 3, and 5 years. The paper I'd recommend that you look into is a paper called AI 2027. And that's when a lot of scientists anticipate what's known as an intellectual explosion. And this is something that was actually predicted in the 50s by a mathematician by the name of I.J. Good. And he basically prophesized, if you will, that once machine learning gets to the point where it can teach itself, it will exceed human cognition, and it will propagate so quickly that we won't be able to control it. It will be smarter than all of us put together. And if something is way smarter than you and there becomes a rift, who do you think is going to win? So that's all I have to say about the existential threats of this. My talk is going to, that's a really fun and scary part, but I'm going to talk about a very much more of a milquetoast type subject matter, and that's generative AI. And I'm going to use as the guide for my talk the three-part report that the Register of Copyright, or Perlmutter, issued parts in 2024, and then 2 parts last year in 2025. Now, let me put Perlmutter in context for you. Perlmutter was, and actually still is, although she was fired by Trump, so y'all hopefully get to talk about it a little bit. She's the Registrar of Copyright, so she heads the Copyright Office. And the Copyright Office sits within the Library of Congress. And the Library of Congress is part of the legislative branch, not the executive branch. Now, the Librarian of Congress is appointed by the president, and the past Librarian of Congress was Hayden, who was appointed by Barack Obama, and the Librarian of Congress appoints the Registrar of Copyright. So Hayden appointed Perlmutter. Now, the Registrar of Copyright has traditionally always been a copyright scholar. This is somebody who has a deep academic background, has worked in the private sector in high-level copyright matters, or has moved up the ranks within the Copyright Office. And Perlmutter is a highly respected copyright expert. Part of the statutory obligations of the Register of Copyright is to periodically engage in studies and then report to Congress on matters both domestic and international that impact the copyright law. Because of the emergence of AI and all the controversies it was creating, in August of 2023, she published a request of inquiry in the Federal Register, basically asking all the stakeholders in the country to respond to a number of questions concerning copyright law and their respective industries. She received over 10,000 comments, and these comments came from a broad spectrum of individuals. Of course, all of the tech bros weighed in, the big large language models. Also, the creative industries weighed in heavily. And we're talking there about unions like SAG, the Screen Actors Guild, the Writers Guild, all kinds of people engaged in the creation of creative art type materials. So you had the Disney Corporation, Paramount Pictures, NBC, all of these people responded, and she took all of this information and went through it and issued a report in 3 parts. The first report, which came out in, I think it was January of 24, or maybe it was later than that, but anyhow, in 24, addressing the quandary of what we generally refer to as deep fakes, she referred to as digital replicas. Now, I'm going to go into that in a little bit detail, but just to give you an overview of the full report. The second part of the report had to do with the copyrightability of content that is created using artificial intelligence. And that's pretty interesting too. And then the third report had to do with the training of the LLM, the large language models, on all of the information that they scraped from the internet and examining a liability for potential copyright infringement as a result of that activity. Okay, so let's talk about digital replicas. What are we talking about here? We're not talking about cartoons. We're talking about realistic depictions of individuals. And I'm sure you've all seen it on your Instagram feed or on Facebook, how realistic the reproductions of individuals can be right now. And every day it only is getting better. I'm very active in the Hawaii film industry, and we're watching with bated breath as the software coming out of China is enabling people with very little computer skills to do perfect replicas of Tom Cruise and Vin Diesel and all of these folks. So the concern is, what are we going to do about this? Now, various states have enacted state laws to address this type of problem. Hawaii actually has a deep fake statute, but it only protects politicians. Imagine that. And political debate, and only within a certain time period surrounding election time. Other states have more robust provisions than Hawaii. And Perlmutter said that we do have this patchwork of different types of laws. Rights of privacy, rights of publicity is probably the most apt field right now to deal with this idea of digital fakes. But we don't have a national law. So we have this patchwork of laws, and it's very difficult to have uniform treatment of something that needs uniform treatment when you're dealing with digital content that is available across the whole country. So I'm not going to dwell too long on this particular part of her report, except to say that she suggested that there should be a new sui generis type federal law that will set kind of like a baseline system or a law to control the digital fakes. It has a lot of characteristics of various states' right of publicity laws. She had recommendations. She recommended that it basically make it a violation of the proposed law to use a digital replication of someone, including the person's voice, without the authorization of that particular person. Now, she suggests that we build in a First Amendment considerations so we don't stifle free speech. She proposed that we build in a safe harbor for online service providers, maybe not as robust as Section 230, but something kind of along those lines. She recommended that the right be licensable but not assignable. The concern there was if somebody can assign the right, you might have young creative people signing away in perpetuity the right to their image, and she thought that was not a very good public policy to put out there. So the recommendation was that you can license it during your lifetime, it would only last for your lifetime, with the safeguards and guardrails put in. And she also indicated that she did not think a postmortem right would be appropriate. But she said, if Congress was so inclined and wanted to include a postmortem right, that the term of the postmortem right would be kept relatively short, like 20 years or so. I should point out that Hawaii has a statutory right of publicity, and I handled with one of my colleagues one of the biggest cases in thus far concerning that particular statute. That was the sale of Jerry rum case and the alleged improper use of sale of Jerry's name in connection with this booze. And as part of that case, Alan Kay, who was the judge hearing the case, found that the legislature was not specifically, it did not specifically articulate that law should have a postmortem effect. And so as a result of that, I ended up drafting an amendment to Hawaii's right publicity statute, providing that the term shall be have retroactive effect. And as a result of that, it brought into the protection of that particular law some of Hawaii's most iconic artists like Israel Kamakawiwo'ole, Don Ho, etc. So Hawaii has made some inroads in this area on the deep fakes, just putting our toes in the water with respect to politicians, and we do have a fairly robust right of publicity statute that does have a postmortem right provision in it. Okay, so that's part one of her report. Congress has not seen fit to go ahead and put forth legislation. I don't think we'll probably see something like that during the present administration's tenure, but we can watch for that on the horizon. Now, part two of the report, which came out in, I think it was March of 25, had to do with the copyrightability of content that is created using generative AI. Okay, so Perlmutter took the position that only humans can become authors of works that are protected by copyright. And she grounded her position in statutory authority. And shortly, let's see, I guess it was around the same time, no, her report, I'm gonna do my timeline screwed up here, but anyhow, so she grounded her opinion squarely in the language of the Copyright Act. When you look at terms like, well, the term of copyright is measured by the life of the author. In the case of non-work for hires, it's the life of the author plus 70 years. And there's lots of other terminology in the statute and a long history of jurisprudence, which never allowed for non-humans to become authors. And if you're not an author, then you're not a human, you're not an author. If you're not an author, then you can not enjoy the benefits of copyright. Now, there's a couple of interesting cases that I'll point out. One was Cetacean Community versus Bush. This was during George Bush's administration. And it was a lawsuit that was filed by a nonprofit organization on behalf of cetaceans. And cetaceans are, of course, whales and dolphins and those kind of folks. And there's a whole group of people that actually think that they're much smarter than we are and they should have the same kind of rights as we got. Anyhow, that case was interesting because it said that whales may actually have Title III standing, but there is no federal law which gives them actual standing. So we had the cetacean case versus Bush, that unless a federal law says that you have the right to pursue something, even though you have Title III standing, it's a no-go. The other case that's really cool is Novato versus Slater. Now, this is the macaque monkey case. And some of you folks may remember several years ago, a wildlife photographer in Indonesia was shooting pictures and he had his camera set up on a tripod and he went for lunch. And while he was gone, this 7-year-old macaque monkey started playing with the camera and took a bunch of selfies. And the selfies went viral all over the place. The photographer kept the photographs and he published them in a coffee table book. And his name was Slater. And he published the coffee table book, and PETA stepped up and alleging that it was a friend of the plaintiff, which was the monkey, they filed a lawsuit. And the lawsuit was pending, and the monkey and the photographer came to an agreement. Well, actually, the monkey didn't come to an agreement, but PETA came to an agreement. And the agreement, if I recall correctly, the agreement was something like the monkey will get, not the monkey, but this organization, he got a bunch of bananas, right? But so the monkey was going to get 25% through Peter, 25% of the proceeds from the book. So Slater and the monkey were satisfied with this. And at that point in time, the case was on appeal in the Ninth Circuit. And so the parties filed a request that the court dismiss the case. And so you would think the court would dismiss the case, but the court said, no, I'm not going to dismiss the case. First of all, the monkey did not sign the settlement agreement. So it cannot be enforced against the monkey. And the court found that Peter did not qualify as a friend of the plaintiff. And following the rule in Citation versus Bush, the Ninth Circuit said, the monkey has Title III standing, and so it went on to address the merits of the case and determined that because the monkey was not a human, it couldn't be an author, and if it couldn't be an author, it had no right to any copyright claim, even though it took the pictures. So the Ninth Circuit wanted to close the loop on that particular case, and I always have this image of the monkey sitting in the witness stand box, anyhow. So that's the Novato case. So then after that, we have the Thaler versus Perlmutter case. Now, this involved a computer scientist who created a bot that created a piece of artwork, and he attempted to register the artwork with the Copyright Office, arguing that his machine, his artificial intelligence, created the artwork and I guess assigned to him the right. And so he fought for the Copyright Office to issue the registration. It went through the administrative processes within the Copyright Office, and eventually it ended up on appeal to the DC Circuit. The DC Circuit affirmed essentially Perlmutter's position, and the case again is Thaler, Thayler versus Perlmutter, basically affirmed Perlmutter's analysis. I shared earlier kind of how she came to the conclusion that only humans could be authors under the Copyright Act. And although I can't say that the court gave Perlmutter's opinion Skidmore defense or deference rather, that the court essentially had the same analysis. Looking at all of the language within the Copyright Act, it's pretty darn clear that you have to be a human to qualify as an author and therefore have any copyright rights. The computer scientist in that case filed a petition for cert with the Supreme Court. And guess what? Just last month, the Supreme Court denied cert. So that DC Circuit is now the law on the subject of whether or not AI can enjoy copyright. Okay, so now we know what the law says. How does that impact what's being done with AI? Well, and I'm going to take it from a registration standpoint, because Perlmutter's really been on this. Over the years, she has been issuing guidance on how to register the copyright to works that are created using artificial intelligence. Now, the bottom line is if the artificial intelligence is the sole author of the work, it's not going to be protected by copyright, and there will be no registration granted. The real question is, what about where it's people using artificial intelligence to create our works? And this could be paintings, this could be textual material, this could be music, it could be almost anything that is subject to copyright. Okay, so the requirement now is that, and it's all the honor system, okay? So there's no like copyright police that are going to check up on this kind of stuff. But when you register a work, you have to indicate it is incumbent upon you, pursuant to the instruction of the Registrar of Copyright, to disclose whether or not AI has been used in connection with the preparation of this material that you seek copyright registration for. And you must be able to articulate with reasonable specificity what AI did and what a human did. And then you must disclaim the content that was created by AI. And then you can only claim copyright in the material which you've been able to articulate with reasonable specificity that was created by a human. Okay, so there are, think of it like a transparency. You can have overlay of what the bottom sheet is, say, a photograph that the human does, and let's say it's a silhouette, and then you use AI to fill in all of the detail. You have to be able to separate those two elements out and be able to say what AI did, what a human did, and you can get copyright protection and get registration for the material that you can, again, specify with reasonable specificity was created by the human. Now, most AI right now responds to prompts. Now, what am I talking about here is you give verbal commands to your bot, and whether you're using a ChatGPT or Gemini or Claude or whatever, generally that's how it's done. Now, Perlmutter took the position that given the doctrine of the idea expression dichotomy in copyright law, that just giving prompts is insufficient to convey full copyright ownership to the human. Let me walk you through that a little bit. So if you say to your bot, I want you to do a picture of a boy in a boat up by the moon with a fishing pole and whatnot, you're giving the bot an idea. And the bot is creating the expression based upon the idea. Copyright does not protect ideas. Copyright only protects specific expression. Okay, so Perlmutter takes the position, and I think it's well taken, that right now, if you use prompts to have AI create a work, that work is not protected by copyright. Now, she does leave room for the fact that as the technology evolves and matures, there may be a point in time when you're giving sufficiently detailed prompts that you will be, think of it like this, is AI the painter or the paintbrush? Okay, now you have programs like Photoshop, etc., that you can use to create things, and that would be protected by copyright. So it's all going to be done on a case-by-case basis. But the easy analogy that I always use when I teach in this area is AI a paintbrush, which is being totally controlled by the human, or is it the painter? And the idea expression dichotomy at this point in time prevents prompts, given the current state of the technology, from giving sufficient human interaction for the human contribution to be protected by copyright. Okay, so that's kind of like drinking out of a fire hose on the utilizing. You got a question?
Yeah, I do. So, I guess in that example you just gave, and then what Perlmutter is saying, with that, if you make a sufficiently detailed prompt that has all kind of parameters, and I know some people are using like JSON or something, to spell out the prompt rather than natural human language, right? So you can be very specific on parameters. That would be okay.
Maybe.
Right?
He's got it running through that same analysis.
Yeah.
Now there's some people have argued, and this was argued in some of the comments, that okay, so I give it a prompt and it gives me something, and I want to refine it. So I get another prompt, refine it, reiterative, etc. And she said that that's really like art creation by roulette. That what you're doing is you're spinning the ball around and you're coming up with something, but AI is still coming up with that other thing, and you're getting thumbs up or thumbs down. In her opinion, you've got your own view of things, right? But I'm saying that's what Perlmutter says. He said, not so much right now.
But wouldn't that be the debate? Is that roulette or is that a conversation?
Well,
you know, we could say, right, a lot of things dealing with AI is a conversation.
Yeah, but remember, AI right now is not really thinking. AI, the AI that you're encountering, whether you're using Claude or any of those, that's a pattern recognition machine that is really not sentient. And so, you know, not to digress here, and there's rabbit holes all through this whole talk. We can go
Right.
down and speak for hours on it. Okay, but you know, when you give it a prompt or something and it goes, oh, it's still thinking.
Yeah.
Bullshit. It's not thinking. It's just looking for more pattern recognition to predict the next thing that should come up. And when that's done at scale, you've got something that sounds like it's really thinking, but it's not.
But it's predicting what you're gonna say.
Well, no, it's predicting what it should say, not what I'm gonna say. It's predicting it. And maybe I can get into that a little bit, talk about what these machines actually do, because in part 3 of the report, which I suppose I should get to, has to do with the training of the LLMs using all of this copyrighted material. Okay, so that's part 2 of the report. Part 3 of the report has an interesting and dicey kind of political component to it. Let's see, now we're in May of 25, and Perlman is working on part 3 of the report, and Hayden, the Librarian of Congress, gets into a pissing contest with Trump, and it's over the books in the Library of Congress. Trump is pushing his, and by the way, if I stray into opinions, these are my personal opinions that I've been in my law firm, blah, 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 blah. Hayden is not carrying the president's torch on DEI and purging of books. And so Trump decides to go ahead and fire Hayden. Query whether he has the right to do that. He has, the Librarian of Congress is appointed by the president, but nothing says the president can fire her. And we got a separation of powers argument here because Library of Congress, like I said, is part of the legislative branch, not the executive branch. So anyhow, Hayden gets fired, and just kind of fast forwarding, she does not file a lawsuit. She's not trying to get her job back. She says, like, good riddance, and she moves on with her life. And so Perlmutter is going, holy crap, he fired Hayden. I wonder if I'm going to be next. I think Hayden was fired on May 8th. And on May 9th of last year, on a Friday night, you know, in the dead of night, Perlmutter releases part 3 of her report in a non-publication form. Now, what does that mean? This is a technicality in the Copyright Office, but normally you have this report and it's all ready to go, but you got to do some fine tuning and maybe you check your citations, blah, 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 whatever. But I think she could, there's a couple of ways to look at this. She saw the axe coming, that she was going to get fired, and was afraid that the administration would deep six this particular report. And so she did a pre-publication release, which is basically unheard of to be done in the Copyright Office by the Registrar of Copyright. And that was released on Friday night, and she was fired the next day on Saturday. Now, why was she fired? Well, you know, we can all speculate about that. What I think happened is the tech pros did not get what they paid for, okay? Now, the tech bros were all interested in, and they anticipated that the Registrar of Copyright would find that when you train these LLMs on copyrighted material, there is going to be copy. You're pulling it off the internet, you're making a copy of it, and you can go all the way back to one of the landmark cases, MAI versus Peak, which basically held that every time you load a piece of software in a computer and it goes into RAM, that a copy has been made. So we have case law, and there was some legislation that kind of addressed that problem because it put computer maintenance people in a bad way. But in any event, once you make a copy and that copy is not authorized, you have a technical infringement of a exclusive right of a copyright holder, and that's the right to reproduce the work. Now, I see I'm running short on time. I really don't have time to get into, but this is super interesting. I see, by the way, you can get all of these reports by going to, excuse me, the Copyright Office. And there's direct links to all three parts of the report. Perlmutter spends a fair amount of time talking about the process of training these LLMs. In a super nutshell way, they make a copy of what they took from the internet. And the stuff that they got, a lot of it is from public facing databases and whatnot. Sometimes it is material that was pirated by a third-party source, and it was on the dark web, and they picked it up there. So it's actually copyright protected information, but somebody had broken in and gotten that and put it on a portion of the dark web or the World Wide Web. But anyhow, for sure, tons of copyright protected information has been scooped up by all of the LLMs that are, and they train it on that. Training, it's not the same thing as making copies. Think of it like this: what they do is they take this content, especially talking mainly here about textual material, and they create tokens. And tokens are little segments of language, either words, portions of words, including spaces and punctuation. And that is given a statistical numerical value. And then they go through this process that they refer to is the weights. And what that is it's predicting, it's a way, it's like instinctual machine learning that allows you to predict after one word, what's the statistical probability of another word following. So these LLMs are basically predicting what comes next. That's why I say that they're not really sentient. They're not actually thinking. It's pattern recognition. We are pattern recognition organisms. We're biological pattern recognition organisms. So anyhow, what they do is they create these tokens and these weights, and it's their position that, hey, we've got section 107, fair use defense here. And because what we're doing is we're engaging in a transformative activity, transforming this into something else. And the content creators push back on that on saying, all you're really doing is you're compressing expression. And at some point, when it comes to the output, that expression is going to be reinflated like a balloon that had been deflated. And now you've got output coming out that's substantially similar to the inputs that came in. So the tech bros were really hoping, my opinion, that their significant contributions to Trump's campaign would result in some fingers on the scales and that we would get some love from the Copyright Office saying that there is a per se section 107 fair use defense because training LLMs are transformative in nature. And Perlmutter said, not so fast. We have to look at the details. She felt that the existing framework for copyright law, especially section 107, which looks at 4 different criteria to determine whether a use is a fair use. And that you need to run through that exercise. So the tech bros were really bummed out about that because they were looking for a free pass on all of this. They didn't get it. And so we still have, I don't know, last count, maybe 70 pending lawsuits throughout the country, mostly in the Ninth Circuit and the Second Circuit, filed by everybody from the New York Times against OpenAI. I'm losing my voice here, guys, sorry. We got tons of these lawsuits that now are not going to be resolved on the basis of just saying, hey, section 107, fair use. They're going to have to run through the 4-part fair use analysis. So let's look at that real quick. We go back to a Supreme Court case called Campbell versus Acuff Rose Music. And that was a really cool case. One of the great things about intellectual property is all the cases are like super cool. That had to do with the rap group Two Live Crew doing a satirical take on Roy Orbison's "Oh Pretty Woman." And the court basically interjected into the vernacular of copyright law the emphasis on the transformative nature of a work. And if a work was truly transformative, in other words, it serves some purpose other than the purpose of the original work that people are alleging has been infringed. Now, let me give you a couple examples of that. When Google was first roaring across everybody's computer screen, they did something as part of a search function where they went to all these websites and they took photographs. Okay. And they made full copies of these photographs. They were full copy photographs, but they were very low resolution. So when you did a search for a particular photograph, you'd get a search return with all these photographs. Well, there you had a situation where Google was reproducing without authorization the entire elements of each photograph, but they were low res. So Google was sued, and the courts ultimately decided that Google was serving a different purpose, that the thumbnail search returns were not a substitute for the real full resolution photographs, and therefore their utilization of copyright protected material was a fair use because it was bringing something else to the table, and that is the ability to do this search. And Google also faced a similar thing with respect to Google Books. Google was basically scanning every book that's ever been written. And the authors all got together and they sued Google Books, and they said, well, you're scanning all of our stuff. And Google Books said, yeah, but it's a transformative use because we're not republishing the entire book. We're only republishing snippets of the book. So people could get a flavor for what the book is. And if you wanted to read the book, you got to go to the senior work and get a copy of that. So those are kind of examples of a transformative use that has qualified as fair use under Section 107, which gives you basically a free pass. It's still technically an infringement, but it's not an actionable infringement. Just, I guess, was last year or the year before, another Supreme Court case was decided. That was the Andy Warhol case. And that kind of pumped the brakes on total reliance upon the transformative use portion of the four-part test. And the four-part test is you look at the nature of the work that is being created. You look at the nature, that's the first one. The second one is the nature of the work that is being used or alleged to have been infringed. And if it's a factual material, it kind of tips in favor of fair use. If it's a creative work, it tips in favor of an infringement. And of course, the first one, if it's transformative, it tips in favor of fair use. The next consideration is the amount and the substantiality of the use that is being made, and that's both a qualitative and a quantitative analysis. Qualitatively, the Google thumbnail case is a perfect example. They're using the entire photograph, but qualitatively, it doesn't substitute for the original because it's what's known as low res, and low res is actually an emerging defense in connection with these kind of copyright cases. And the last one is, and this is what became super important in the Warhol case, is does the output act as a substitution or potential substitution for the work that has been allegedly infringed? And if you're taking away market share, if you're diminishing the opportunity for licensing revenues, et cetera, if it's operationally a potential substitute under Warhol, that it can trump the transformative nature of the usage. So I know this is drinking out of a fire hose. That's pretty much part 3 of the Perlmutter's report. By the way, Perlmutter sued, and she was reinstated. I believe it was by the DC Circuit. So she's got her job back. but it's pending constitutional arguments regarding separation of powers and whether the president had the authority to fire her in the first place. Okay, so I think we got 10 minutes.
Yeah, so we'll open up the floor for questions here in person, and for those that are on Zoom, you can put your questions in chat and then we'll get to them, but I guess we can open up the floor for here first, if anyone has any questions.
No questions on the line, yeah.
I was kind of curious, if you watch YouTube a lot, and you got all these, my wife and I are Star Wars fans, so you got these little fan-made movies. The characters look like the actors themselves, younger, of course. And we're just thinking, they make the disclosure, it's fan-made, we're not tied to Disney and whatnot. But we're always wondering, how is it they don't get sued by Disney or the actors by doing what they're doing? Using.
Sorry, could you give me the facts again? People are doing homemade replicas of real people?
Well, it's like, you have a story, Star Wars, the Star Wars, and there's a story. They have the characters that you see in movies in their prime, I guess you could say. I mean, they're in their 20s or 30s, not like how they are now in the 60s or 70s. They have a story, they use the same characters, same music almost. Yet they have things say we're a fan-made movie, we're not tied to Disney.
Okay, but what I think you're touching on there is whether or not copyright protects a particular style
Okay.
of a work, and it does not. And that takes us back into the idea expression dichotomy. So now there are some platforms that, for example, Suno and other music platforms, you cannot use as a prompt. And it's not because of the law, but they just decided to do this to, I guess, get goodwill with people using the system and with the artistic community. So if you try a prompt, say, I want you to do a song in the style of Taylor Swift, and it will reject that prompt. But taking back, I think, to your question, copyright protects particular expression. So, for example, if you got Star Wars and you got the Stormtrooper uniform,
Right.
okay, if they've registered the copyright to a particular image with all of the elements of that costume, then they have copyright protection in that, and they might very well have a infringement claim. Oftentimes, there's business decisions that are made where they'll let a lot of this stuff go because it adds to the value of their particular content. So I, without having more facts, I can't really address the specific facts, but it's a nice segue into this adjacent issue, which is the style of performance. Is style of artwork protected? No, it's not. But if you take a particular snapshot of something, those elements can be protected. Of course, if it's by a human, they can be protected by copyright. And it's possible for style to kind of slowly segue into protectable elements, but it's really on a case-by-case basis that you got to analyze that.
Right, I got a question in chat, asking, who is the author of the report that you were talking about?
Shira Perlmutter. Shira Perlmutter, and she is the current registrar of copyright. When she came out with part 3 of the report, like I said, she was fired, filed a lawsuit, said you can't do that. The court reinstated her pending argument on the constitutional issues regarding separation of powers.
Okay, and then next question in chat, what if there are multiple iterations of the work, example, many prompts for a picture, as for written works where there is a human in the loop editing the work? Does this mean the work is authored by both generative AI and the author?
Yes. Yes, it is. And so what you have to do is you have to be able to articulate with reasonable specificity what AI did and what the human did. And you have to disclaim what the AI did, and you can only get copyright protection for what you did. Now, like I said, there's no copyright police, so it's on the honor system. But if you lie or you stretch it, if you're ever challenged, you could have your registration removed, and that wouldn't be good.
Okay, all right, does anyone have any other questions in the room? Anyone in chat wants to put a question? If not, is there any way that like people could maybe contact you perhaps? Okay.
Actually, rates that.
There's a question.
Oh, yeah.
Oh, yeah, okay.
You know, you're talking about, copyrights for personal authorship, you know, versus work for hire. So what is the distinction between those two as far as, you know, well, a lot of corporations are gonna do work for hire, right? So
Right.
that, you know, dominant side.
Well, okay, work for hire is a legal fiction. Okay, you still need a human in the loop.
Correct.
Okay, so what happens is you sign a document saying, I'm gonna be making a bunch of stuff for Disney, I'm an illustrator or whatever, and you're gonna own the copyright, so there's still a human in the process. And so work for hire requires still a human, because human is the only one that can be an author. But the legal fiction says that ab initio, from the time the work was created, the corporation is gonna own it by virtue of the agreement with the corporation, so it's a contractual arrangement, but it's supported by the work for hire provisions of the Copyright Act.
So then it's like, what, 120 years?
Yep.
Okay, got it.
But it's still has a connection back to the life of the
Right,
author.
still gotta be a human involved,
That's right.
that's hired.
Yeah, now, I should say, all of this can change by Congress.
Yeah.
Congress, I mean, Article 1, Section 8, Clause 8 of the US Constitution says that Congress shall be empowered to grant for authors for limited times the exclusive right to their writings, and the patent provision is also in there, and that's why copyright patent law is basically constitutionally based.
Right.
But so Congress can change things. Congress can say, yeah, AI can qualify. Maybe it'll come up with some hybrid type arrangement, which is borrows a little bit from work for hire or something like that. But so we'll see. As far as I know, there's been no legislation introduced to do that. But I can see it coming down the pike for sure.
Yeah. Okay.
All right, I don't think there's any other questions in chat, but you said, were you willing to give out a contact information?
Yeah, I can be reached at W Meyer, Meyer, at settle, SETTLE, Meyer, Meyer, law, LAW.com.
Okay, I should type that in.
No,
For chat. It's fine, it's fine. It's fine.
seriously, okay, I'm stuck with this.
It's
How about a hand?
See, I told them.
Yeah.
You can also look at the back as well to see what you're typing.
Don't let AI do it.
With the AI.
Did that make sense?
Yeah. So. I got it. I think the 2 was supposed to be an at G,
Okay.
right?
Okay, well, thanks a lot for enduring this. Like I said, it's one of my favorite topics in the world. Watch out for our robot overlords. They are coming for us.
Okay, all right, with that, I guess that concludes today's Senior Council Division coffee hour. Next one will be on May 7th. At around the same time, and we hope everyone will join us for that as well. Topic is Jerry.
Oh, I have a title for it. It's fall prevention.
Okay.
Yeah.
All right, with that being said, thank you, everyone. Have a great 3D weekend if you have it. If not, have a great day.
Thank you.